Let's take a look at Title VII of the 1964 Civil Rights Act. Employers cannot discriminate based on race, color, religion, sex, or national origin. Specifically, the Act states that it shall be an unlawful employment practice for employers to refuse to hire or otherwise discriminate against anyone with respect to the privileges of employment because of their race, color, religion, sex, or national origin, or to limit or classify employees or applicants for employment in any way that would adversely affect employment opportunity or status because of their race, color, religion, sex, or national origin. Title VII bars discrimination on the part of most employers, including all public or private employers of 15 or more persons and most labor unions. It bars public and private employment agencies from failing or refusing to refer for employment any individuals because of race, color, religion, sex, or national origin. Title VII established the Equal Employment Opportunity Commission, known as the EEOC, to administer and enforce Civil Rights Act at work. It consists of 5 members serving 5-year terms appointed by the President with the consent of the Senate. Thousands of EEOC staff around the United States receive and investigate job discrimination complaints from aggrieved individuals. When EEOC finds reasonable cause that charges are justified, it attempts, through conciliation, to reach an agreement. If this fails, it can go to court. The EEOC may file discrimination charges, or the individual may file on behalf of themselves. It's unlawful to discriminate in pay on the basis of sex when jobs involve equal work. Pay differences derive from seniority systems, merit systems, and systems that measure earnings by production, quantity, or quality, or from any other factor other than sex, do not violate the Act. Unfortunately, women still earn only about 70% as much as men in similar jobs. The ADEA made it unlawful to discriminate against those between age 40 and 65 years. Subsequent amendments effectively ended most mandatory retirement age of 65. Most states and local agencies, when acting as employers, must also adhere to the ADEA. You can't get around the ADEA by replacing employees who are, say, 60 with someone over 40. In one case, the U.S. Supreme Court held that an employee who is over 40 years of age might sue for discrimination if a significantly younger employee replaces them, even if the replacement is also over 40. To guard against age prejudices, it's advisable to have an anti-harassment policy for older workers. The Vocational Rehabilitation Act requires employers with federal contracts of more than $2,500 to take affirmative action in employing handicapped persons. It does require that an employer take steps to accommodate a handicapped worker unless doing so imposes an undue hardship. It does not require hiring unqualified people. The Pregnancy Discrimination Act prohibits using pregnancy to discriminate. Furthermore, under the Act, if an employer offers its employees disability coverage, then it must treat pregnancy and childbirth like any other disability and include it in a plan as a covered condition. Managers should base any employment decision on whether an employee can do the job on medical documentation, not on their interpretation. More women are suing for discrimination under this Act. These guidelines spell out recommended procedures for complying with the law. The EEOC, Civil Service Commission, Department of Labor, and Department of Justice together issued uniform guidelines. These set forth highly recommended procedures for things like employee selection and record keeping. As an example, they specify that employers must validate any employment selection devices like tests that screen out disproportionate numbers of women or minorities. They also explain how to do so. The EEOC and other agencies also periodically issue updated guidelines clarifying and revising their positions on matters such as sexual harassment. The American Psychological Association has its own standards that do much the same thing. Several court decisions helped clarify courts' interpretations of EEO laws. Griggs was a landmark case because the Supreme Court used it to define unfair discrimination. Lawyers sued the Duke Power Company on behalf of Willie Griggs, an applicant for a job as a coal handler. The company required its coal handlers to be high school graduates. Griggs said that this wasn't related to success on the job, and it resulted in more blacks than whites being rejected for those jobs. Griggs won the case in a unanimous decision. In the written opinion, Chief Justice Berger laid out three crucial guidelines affecting equal employment legislation. First, the court ruled that discrimination does not have to be overt to be illegal. The plaintiff does not have to show that the employer intentionally discriminated against the employee or the applicant. Second, the court held that an employment practice must be job-related if it has an unequal impact on members of a protected class. For example, if arithmetic is not required to perform the job, don't test for arithmetic. Third, Chief Justice Berger's opinion placed the burden of proof on the employer to show that the hiring practice is job-related. Title VII does not forbid testing. However, the test must be job-related or valid, in that performance on the test must relate to performance on the job. If the employer wants to test candidates for a job, then the employer should first clearly document and understand the job's duties and responsibility. Furthermore, the job's performance standards should be clear and unambiguous. That way, the employer can identify which employees are performing better than others. The court also established the EEOC guidelines on validation. The Civil Rights Act of 1991 rolled back equal employment law and put more responsibility on employers. Burden of proof, what the plaintiff must show to establish possible legal discrimination, and what the employer must show to defend its actions, plays a critical role in equal employment cases. Once an aggrieved applicant or employee demonstrates that an employment practice has an adverse impact on a particular group, then the burden of proof shifts to the employer, who must show that the challenged practice is job-related. Before the Civil Rights Act of 1991, victims of intentional discrimination, which lawyers call disparate treatment, who had not suffered financial loss and who sued under Title VII could not then sue for compensatory or punitive damages. All they could expect was to have their jobs reinstated or to get a particular job. They were also eligible for back pay, attorney's fees, and court costs. The Civil Rights Act of 1991 makes it easier to sue for money damages in such cases. It provides that an employee who is claiming intentional discrimination can ask for compensatory damages. They can also ask for punitive damages if they can show the employer engaged in discrimination with malice or reckless indifference to a federally protected right of an aggrieved individual. Some employers in mixed motive cases had taken the position that even though their actions were discriminatory, other factors like the employee's dubious behavior made the job action acceptable. Under the Civil Rights Act of 1991, an employer cannot avoid liability by providing that it would have taken the same action, such as terminating an employee, even without the discriminatory motive. If there's any such motive, the practice may be unlawful. The Americans with Disabilities Act prohibits discrimination against disabled individuals. It prohibits employers with 15 or more workers from discriminating against qualified individuals with disabilities with regard to hiring, discharge, compensation, advancement, training, or other terms of employment. It also says employers must make reasonable accommodation for physical or mental limitations unless doing so imposes an undue hardship on the business. The ADA does not list specific disabilities. Instead, the EEOC has guidelines that say someone is disabled when they have a physical or mental impairment that substantially limits one or more major life activities. The Act specifies conditions that it does not regard as disabilities, including homosexuality, compulsive gambling, pyromania, and certain disorders resulting from the current illegal use of drugs. Mental disabilities account for the greatest number of ADA claims. Under the EEOC ADA guidelines, mental impairment includes any mental or psychological disorder such as an emotional or mental illness. The guidelines say employers should be alert to the possibility that traits normally regarded as undesirable may reflect mental impairments. Reasonable accommodation might then include providing barriers between workspaces. The individual must have the requisite skills, educational, and experiential background. A job function is essential when it's the reason the position exists, or it's so specialized that the employer hires the person to perform that particular function. If the individual can't perform the job as currently structured, the employer must make a reasonable accommodation unless doing so would present an undue hardship. Reasonable accommodation might include redesigning the job, modifying work schedule, or modifying or acquiring equipment or other devices, widening door openings, or permitting telecommuting as an example. The ADA Amendments Act of 2008, or the ADAAA, made it easier for employees to show that their disabilities are influencing one or more major life activities such as reading and thinking. Common employer concerns about people with disabilities are generally baseless. The Uniformed Services Employment and Reemployment Rights Act is known as USERRA. Under USERRA, employers are generally required, among other things, to reinstate employees returning from military leave to positions comparable to those they had before leaving. USERRA also prohibits employers from discriminating against service members. The Genetic Information Non-Discrimination Act of 2008 is known as GINA. GINA prohibits discrimination by health insurers and employers based on people's genetic information. Specifically, it prohibits the use of genetic information in employment and prohibits the intentional acquisition of genetic information about applicants and employees. It also imposes strict confidentiality requirements. All states and many local governments prohibit employment discrimination. The state or local law usually covers employers like those with less than 15 employees not covered by federal legislation. State and local equal employment opportunity agencies, often called human resource commissions or fair employment commissions, also play a role in equal employment compliance. When the EEOC receives a discrimination charge, it usually defers it for a limited time to the state and local agency to have comparable jurisdiction. If it doesn't achieve satisfactory remedies, the charges go back for EEOC resolution. The EEOC enforces laws prohibiting discrimination based on age, disability, equal pay or compensation, genetic information, national origin, pregnancy, race, color, religion, retaliation, sex, and sexual harassment. Religious discrimination is treating someone unfavorably because of their religious beliefs. The law protects not only people who belong to traditional, organized religions, but also others who have sincerely held religious, ethical, or moral beliefs. Unless it would be an undue hardship on the employer must reasonably accommodate the employee's religious beliefs or practices. This applies to schedule changes or leave for religious observances, as well as such things as religious dress or grooming practices. One question is how far employers must go to accommodate employees' religious practices. The EEOC found reasonable cause that food giant Cargill violated Title VII by telling Muslim employees at one plant they couldn't have prayer breaks. What is reasonable depends partly on how disruptive the accommodation will be. For example, such breaks might be too disruptive for high-speed production lines. Some trends expand equal employment's impact while others are forming new headwinds. The U.S. Supreme Court held that the Federal Defense of Marriage Act's exclusion of state-sanctioned same-sex marriages was unconstitutional. In 2014, then President Obama signed an executive order barring federal contractors from discriminating against lesbian, gay, bisexual, and transgender employees. The DOL passed regulations requiring that federal contractors employ a minimum of 7% of disabled workers or face penalties, possibly including loss of their contract. Recent decisions may produce headwinds. The U.S. Supreme Court upheld a Michigan constitutional amendment banning affirmative action in admissions to the state's public universities. This may allow voters in other states to eliminate affirmative action-based admissions to their public universities. And in two other decisions, the court made it more difficult for someone to bring a retaliation claim against an employer. It may also more strictly define supervisor, reducing the likelihood that someone could show that an employer was responsible for a supervisor's harassing behavior. With its stated goal of reducing regulations, the Republican administration could be less supportive of EEOC regulations and regulations in general. Religious organizations could employ only those who hold the same religious beliefs, as an example. Under Title VII, sexual harassment generally refers to harassment on the basis of sex when such conduct has the purpose or effect of interfering with work performance or creating an intimidating, hostile, or offensive work environment. In one recent year, the EEOC received 11,717 sexual harassment charges. Under EEOC guidelines, employers have an affirmative duty to maintain workplaces free of sexual harassment and intimidation. The Civil Rights Act of 1991 permits victims of discrimination, including sexual harassment, to collect compensatory. EEOC guidelines define sexual harassment as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature that takes place under any of the following conditions. Submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment. Submission to or rejection of such conduct by an individual is used as a basis for employment decisions affecting such individual. Such conduct has the purpose or effect of unreasonably interfering with the individual's work performance or creating an intimidating, hostile, or offensive work environment. There are three main ways someone can prove sexual harassment. The most direct is to prove that rejecting a supervisor's advances adversely affected what the EEOC calls a tangible employment action, such as hiring, firing, promotion, demotion, or work assignment. Hostile environments are created by supervisors. The harassment need not have tangible consequences, such as demotion. Hostile environment sexual harassment generally means the intimidation, insult, or ridicule were sufficiently severe to alter the employee's working conditions. Courts look at whether the discriminatory conduct is frequent or severe, whether it's physically threatening or humiliating, or a mere offensive utterance, and whether it unreasonably interferes with an employee's work performance. An employer can defend itself against sexual harassment liability by showing two things. First, it must show that the employer exercised reasonable care to prevent and correct promptly any sexual or harassing behavior. Second, it must demonstrate that the plaintiff unreasonably failed to take advantage of any preventative or corrective opportunity provided by the employer. The employee's failure to use formal reporting systems would satisfy that second component. Adverse impact plays a central role in discriminatory practice allegations. Under Title VII and the Civil Rights Act of 1991, a person who believes that they were a victim of unintentional discrimination because of an employer's practices need only establish a prima facie case of discrimination. This means showing, for instance, that the employer's selection procedures, like requiring a college degree for a job, did have an adverse impact on a protected minority group. So, for example, if a minority applicant feels he or she was a victim of discrimination, the person need only show that the employer's selection process resulted in an adverse impact on his or her group. Then the burden of proof shifts to the employer. It becomes the employer's task to prove that its test is a valid predictor of performance on the job. In practice, an applicant or employee can use one of 5 methods to show that an employer's procedure has an adverse impact on a protected group. The disparate rejection rate method compares the rejection rates for a minority group and another group, usually the remaining minority applications. Federal agencies use the 4/5 rule to assess disparate rejection rates. Similarly, the courts have used the standard deviation rule to confirm adverse impact. The restricted policy approach means demonstrating that the employer's policy intentionally or unintentionally excluded members of a protected group. The population comparison approach compares the percentage of minority or protected group and white workers in the organization with the percentage of a corresponding group in the labor market. Lawyers use these approaches to test whether policies screen disproportionately. An employer can claim that the employment practice is a BFOQ for performing the job. Title VII provides that it should not be an unlawful employment practice to hire an employee on the basis of a protected class in certain instances where it is reasonably necessary to the normal operation of that business. However, courts usually interpret the BFOQ exception narrowly. It's usually a defense to a disparate treatment case based upon direct evidence of intentional discrimination rather than disparate impact or unintentional cases. The Age Discrimination in Employment Act, ADEA, permits disparate treatment in those instances when age is a BFOQ. For example, age is a BFOQ when the FAA sets a compulsory retirement age of 65 for commercial pilots. Actors required for youthful or elderly roles suggest other instances when age may be a BFOQ. However, courts set the bar high. The reason for age limits must go to the essence of the business. Religion may be a BFOQ if religious organizations or societies require employees to share their religion. For example, religion may be a BFOQ when hiring persons to teach at a religious school. Gender may be a BFOQ for positions like an actor, model, or restroom attendant requiring physical characteristics possessed by one sex, though it's difficult to claim. For example, it's not a BFOQ to say that the position requires lifting heavy objects. A person's country of national origin may also be a BFOQ. Business necessity is a defense created by the courts in discrimination claims. It's not easy to prove business necessity. The Supreme Court made it clear that business necessity does not encompass such matters as avoiding employer inconvenience, annoyance, or expense. The Second Circuit Court of Appeals held that business necessity must not only directly foster safety and efficiency, but also be essential to those goals. Furthermore, it must be sufficiently compelling to override any racial impact. However, many employers use the business necessity defense successfully. In general, when a job requires a small amount of skill and training, the courts closely scrutinize any pre-employment standards or criteria that discriminate against minorities. There is a correspondingly higher burden when the job requires a high degree of skill and when economic and human risks of hiring an unqualified applicant are great. Attempts by employers to show that their selection test or other employment practices are valid are examples of the business necessity defense. Here, the employer must show that the test or other practice is in fact job-related. Validity means the degree to which the test predicts performance on the job. The EEOC refers about 10% of its charges to a voluntary mediation mechanism. If the parties don't reach agreement, or one of the parties rejects participation, the EEOC processes the charge through its usual mechanisms. Faced with an offer to mediate, the employer has three options. They can agree to mediate the charge, they can make a settlement offer without mediation, or prepare a position statement for the EEOC. If the employer does not mediate or make an offer, the position statement is required. It should include a robust defense. Many employers require applicants and employees to agree to arbitrate such claims to avoid litigation. The EEOC does not favor mandatory arbitration. However, the U.S. Supreme Court's decisions make it clear that employment discrimination plaintiffs may be compelled to arbitrate their claims under such circumstances. Given this, employers may wish to consider inserting a mandatory arbitration clause in their employment applications or handbook. To protect such a process against legal appeal, the employer should institute steps to protect against arbitrator bias, allow the arbitrator to offer a claimant board relief, and allow for reasonable amounts of pre-hearing fact-finding. Alternative dispute resolution is a grievance procedure that provides for binding arbitration as the last step. Workforce diversity produces both benefits and problems for employers. Unmanaged, it can produce behavioral barriers that reduce cooperation. Potential problems can include stereotyping, where someone ascribes specific behavioral traits to individuals based on their apparent membership in a group. Prejudice is a bias towards prejudicing someone based on personal traits, as in, we don't hire him because he's old. Some people's biases are subconscious. Discrimination is prejudice in action. It means taking specific actions towards or against a person based on their group. Of course, it's generally illegal to discriminate at work based on someone's age, race, gender, disability, or national origin. Tokenism means a company appoints a small group of women or minorities to high-profile positions rather than more aggressively seeking full representation of that group. Ethnocentrism is the tendency to view members of other social groups less favorably than one's own. In one study, managers attributed performance of some minorities less to their abilities and more to the help they received from others. The same managers attribute the performance of non-minorities to their own abilities. The key is properly managing diversity's potential problems. Managing diversity means maximizing diversity's potential benefits while minimizing the potential problems, such as prejudice, that can undermine cooperation. Compulsory actions, particularly EEO law compliance, can't guarantee cooperation. Managing diversity also relies on taking voluntary steps to encourage employees to work together productively. The employer may institute a diversity management program, usually at the initiative of a top executive. The program's main aim is to make employees more sensitive and to be able to better deal with cultural differences. First, make such diversity training the solution, or if some other approach is more advisable. Next, set measurable program goals, for instance, in terms of quantifiable attitudes towards diversity. Provide strong leadership. Organizations with exemplary reputations in managing diversity typically have CEOs who champion the cause of diversity. One study found that the most common tools for assessing a company's diversity include equal employment hiring and retention metrics, employee attitude surveys, management and employee evaluations, and focus groups. Provide diversity training and education. The most common starting point for diversity management efforts is usually some type of employee education program. Change culture and management systems. Combine education programs with other concrete steps aimed at changing the organization's culture and management systems. Evaluate the diversity management program. The problem can be that many diversity programs are ineffective. Some fail because even positively inclined employees may resist participating in mandatory programs. Others fail by providing a false sense of security. Others design their diversity efforts to elicit employees' engagement and active participation. Equal employment opportunity aims to ensure that anyone, regardless of race, color, disability, sex, religion, national origin, or age, has an equal opportunity based on their qualifications. Affirmative action means taking actions to eliminate the effects of past discrimination. Affirmative action is still a significant workplace issue. The incidences of major court-mandated affirmative action programs are down, but courts still use them. For example, Executive Order 11246, issued in 1965, requires federal contractors to make affirmative action to improve employment opportunities for groups such as women and racial minorities. The key aims of affirmative action programs are to use numerical analysis to determine which, if any, target groups the firm is underutilizing relative to the relevant labor market and to eliminate the barriers to equal employment. Many employers pursue these aims with a good faith effort strategy. This emphasizes identifying and eliminating the obstacles to hiring and promoting women and minorities, and increasing the minority or female applicant flow. Avoiding employee resistance to affirmative action programs is important. Here, studies suggest that current employees need to believe the program is fair. Transparent selection procedures, explaining clearly what selection tools and standards the organization uses, will help in this regard. Communication is also important. Show that the program doesn't involve preferential selection standards. Provide details on the qualification of all new hires. Justifications for the program should emphasize redressing the past discrimination. Reverse discrimination means discriminating against minority applicants and employees. In 2009, the U.S. Supreme Court ruled an important reverse discrimination suit brought by Connecticut firefighters. In this case, 19 white firefighters and one Hispanic firefighter said the city of New Haven should have promoted them based on their successful test scores. The city argued that certifying the test would have left them vulnerable to lawsuits from minorities for violating Title VII. The court ruled in favor of the predominantly white plaintiffs. In New Haven's desire to avoid making promotions that might appear to adversely impact minorities, Justice Kennedy wrote that the city rejected the test results solely because the higher scoring candidates were white. The consensus of observers was that the decision would make it harder for employers to ignore the results obtained by valid tests, even if the results disproportionately impacted minorities. Employers should base employment decisions on legitimate criteria.